Let's look at a scenario that would be worth discussing for sure. Say you're showing a house to a buyer and you're walking through and you happen to look up and notice that there's a wet spot in the ceiling, maybe in one of the bedrooms or whatever. But anyway, there's a wet spot in the ceiling. And obviously your buyer's going to ask you, well, why do you suppose the ceiling is wet? Well, typically you might respond with, well, apparently it would appear that the roof is leaking. I will just tell you, if you say that the roof is leaking, that roof better be leaking. Because if it's not, you could be liable for that. So what I'm trying to get you to understand and see right here is, one, limit your expertise. Even if you are a contractor, which most real estate agents are not, but even if you are, I suggest you stay in your role as a real estate agent. But assuming you're not a contractor, then you absolutely have no business trying to determine why the ceiling is wet. Now, look, is it possible, in fact, probable that maybe the roof is leaking? Sure. But you don't know that. Maybe there's a water line up there that's leaking, or or whatever. I mean, there's all there's several reasons why the ceiling could be wet. And the problem with you just throwing an answer out there and not knowing the right answer is your client's going to rely on that. They're going to be making decisions based on what you said. What you said, the roof was leaking. So they may come in with a very low offer thinking, well, we're going to have to spend $10,000 to get our roof replaced or get the roof replaced if we buy the house, when the reality is only a couple $100 in plumbing issue. But you may had them make a pretty bad offer based on information that you were just wrong, and which cost them the deal. Stay in your lane, okay? You're a real estate agent. Don't be giving that kind of advice. Could they ask you questions that might be considered legal in nature? I promise you they will. Don't answer it. First of all, you cannot be giving legal advice. You're not an attorney. They may ask you, well, if I buy this house, how will this affect, or will it affect my taxes at the end of the year? Well, I can about tell you it will. Now, whether it be good or bad, I don't know. You should not be answering those questions. You're not their accountant. You're a real estate agent. Stay in your lane and do not try to answer every single question. Okay. Now, I don't have a problem with you getting the answer from the expert. Could you contact an attorney on their behalf to get an answer to their question? I don't have a problem with that. Or could you contact potentially an accountant to get an answer to their question? I'd be careful about some of that, but at the end of the day, don't you be the source of the information, okay? You get that information from those that are considered experts. All right. Now, the other thing we're looking at right here are different types of liability. Obviously, you have what we call joint liability, which means if we have a legal situation, under joint liability, both the agent and the subagent would both be liable, meaning the broker in charge and you as the licensee would both have liability here. That's what they're talking about when they say joint liability. Next thing you see, there's several liability. Well, what does several mean? I know that some of you are going to shake your head at it, but several, at least in this scenario, means one. It just means one. So several liability just means there's only one person or one party that's liable for their own action. If it's something the licensee did or the subagent, then licensee, you're liable, not the broker in charge. Now, if there's something the broker in charge did, then obviously then they would be liable and not the licensee or subagent. That's several liability. But then there's this vicarious liability. And and I will tell you, this is one that, or form of liability, you better be careful with, especially if you ever one day decide to become a broker in charge. And what they're talking about here under vicarious liability. Is it possible, let's say I'm your broker in charge, you're a licensee of mine. Is it possible, because of the involvement you have with a particular transaction, that you could have or know some things about the transaction or things going on that I would not know? Because I'm not involved with it like you are. Is that possible? Well, yes. There's always going to be times when the licensee will have information or knowledge about situations that the broker in charge would not have, just because they're not as deeply involved. Well, when it comes to vicarious liability, basically what it's saying is this: if you're the broker in charge and your licensee knew it or had knowledge about something, then so did you, broker in charge. Whether you did or not is irrelevant. If your licensee knew it, then you knew it. And I guess the theory behind it is, if you're properly supervising and managing all the transactions going on within your office, then you should know. But I'm going to tell you, it just doesn't really work like that in the real world. But in a court of law, if the courts determine that your liability had certain knowledge, then broker in charge is going to be assumed that you knew it as well. Whether you did or not, again, is going to be irrelevant. All right, moving on. Now let's look at some types of agents. There's 3 types of agents, and I highly suggest you be familiar with them. Make sure you know the difference in these 3 types of agents. First one is what we call a universal agent, and it says this type of agent typically has very broad authority when acting on behalf of their principal. They got a lot of authority. In fact, an example I think I even use in my book. I don't know how common an example this would be, but it's still a good example. So I'll hit on it real quick. But say Walmart hires me to, they're looking for land to build a new Walmart. Okay. So they might hire me and say, all right, Frankie, we want you to just go out into the world and look for the next perfect location for a Walmart supercenter. And once you find it, just go ahead and buy it. And then we'll come out and build a new Walmart. That's an awful lot of authority right there, which is not typical of what most real estate agents do. Okay? But that's what universal agents do. They have very extreme authority in some cases, very broad authority. Another probably realistic example that you might see more often than that is maybe if you have a real estate agent acting as, or maybe they have power of attorney to act on behalf of their client. Maybe they can actually sign contracts, offers, and so forth on behalf of their clients because they've been given power of attorney to do that. That might be considered a universal agent as well. But again, because of the power of attorney, that gives them very broad, very extensive authority when representing their principal. But then these other 2 agents are a lot more common that you see in your typical real estate transactions. The next one is the general agent. Here it says a general agent is an agent of an agent. That would be you. You'd be the licensee or a sub-agent. If you're an agent working under the authority or supervision of another agent, then that means you are a general agent or sub-agent, we refer to them as. And then the third one is the special agent, and that's the broker in charge. That's the agent. That's the one that is personally hired to represent the principal, right? So the agent is the special agent is the broker in charge. And well, this may not sound good, but it helped me when I was taking the state exam, but I kind of remembered it this way. If you're the broker in charge, don't you have to be special? Yes. But if you're not the broker in charge, then you're just general. Okay? Now, again, sorry if it didn't sound good, but worked for me. If it didn't work for you, you can figure out another way to remember it yourself. But y'all make sure you know the different types of agents. And then there are also 3 types of principals. Y'all, and again, remember we said who's the principal? It's whoever you're working with and or representing. It could be the buyer or it could be the seller. But there's 3 types of principals, and y'all, this is something you will have to ask all buyers and or sellers, all principals, to make sure you know what type principal they elect to be and how they want to be represented. The first choice is a fully disclosed principal. What they're talking about here, let's say I'm representing the buyer and they have chosen to be a fully disclosed principal. What that means is this: when I am dealing with or talking to a seller, or maybe the seller's agent, the listing agent, that means I can basically tell them 2 things. I can tell that seller, one, that I'm not the buyer, I represent the buyer. And I can also tell the buyer, I can also tell the seller who the buyer is. So really we're talking about 2 things that's being disclosed here. One, who the principal is, and that I'm representing the principal. That's what we're talking about disclosing when we're talking about fully disclosed principal. Now, if the buyer in this example chooses to be an undisclosed principal, that means I cannot disclose to the seller or their agent who the buyer is, nor can I tell them that I'm representing the buyer. So if you think about it, who do you think the seller might think the buyer is in a situation like that? Obviously the seller's going to think you're the buyer, right? Because you can't tell them that you're representing the buyer, nor can you and you certainly can't tell them who the buyer is. So obviously the seller is just going to be thinking that you are the buyer, which is where this, again, power of attorney may come into play, where you may actually be operating as a universal agent, right? But that's an undisclosed. But then there's the partially disclosed principal. And it kind of means what it sounds like. That means I can disclose part of the information. Remember the 2 things we're dealing with here. I can disclose part of it. So if my buyer chooses to be partially disclosed, that means I can tell the seller, I am not the buyer. I represent the buyer. But I cannot tell you who the buyer is. Okay? So that's disclosing part of it. So all I can tell them is I represent the buyer, but I cannot tell you who the buyer is. Make sure you understand the different types of principles. And obviously this is something you'll be asking every buyer and or seller to make sure you know which type principal they want to be, so you know how to represent them. And then just a couple things here about agency relationships that I think we've already talked about or hit on at some point, but just to make sure we got it. When it comes to the agency relationship, obviously it could be formed orally or in writing, or it could be created orally or in writing. If it's not in writing, remember that's what we call implied agency, where parties have just believe that we have an agency relationship even though there's nothing in writing. Be careful with the implied agency, because I'm telling you, a lot of states, if not most states, will not allow implied agents. In fact, it's illegal in many states. Again, when we get in state-specific portion of the course, we'll make sure we address it again to ensure that we know whether it's legal in your state or not. Obviously, agency relationships must be consensual, agreed to by all parties. In other words, someone can't be forced into it, pressured into signing a contract. If they are pressured into it, then it's not going to be valid or enforceable. Everything has to be consensual. And then this third bullet here, where it's talking about compensation versus gratuitous services. This is something you need to be aware of and certainly be careful of. First of all, say you're going to list a house for sale on behalf of a homeowner. Well, do you have to get paid for your services? Do you have to charge for your services? Let me say it that way. No. If you don't want to charge for your services, you're more than welcome to do that. And that's what they're talking about, a gratuitous service. So, you could represent a buyer or a seller and not charge them for it. Now, you might be thinking, well, why in the world would I do that, or who would do that? Well, let's say Mama wants to sell her house. Well, who is Mama likely going to be calling to sell the house? Well, hopefully you, right? Because you're her child, you're her baby, and she wants you to help her sell her house. Well, a lot of people might think, if Mama wants to sell her house, I'm not going to charge Mama for that. Mama's done enough for me in my lifetime. I can help her sell her house without charging for it. Now, I get it. There's going to be some of y'all are already thinking, I'm charging Mama. In fact, I'd probably charge Mama double what I would normally charge anybody else, just because I know she'd pay it. Look, to each his own. You do whatever you got to do. But, just want to make sure you understand the difference between compensation and gratuitous services. And what you got to have, where you got to be careful here, I'm telling you, a lot of real estate agents gotten in trouble over this. In fact, where they've gotten in trouble is, they were, and again, I'm in South Carolina, so I'm giving you this example based on South Carolina laws. Just keep that in mind. The law may be a little bit different in the state you're in. But, in South Carolina, implied agency is illegal. Okay. Well, what a lot of agents will do, they'll think, well, Mama, I'll help Mama, and I'm not going to charge her for it. Nothing wrong with that. Well, just because you're not going to charge for your services, if you're going to provide the service, then you must have an agency relationship. And at least in my state, in South Carolina, it must be a written agreement. So Mama must sign a written agency agreement hiring me to represent her. Now, again, in the agreement, you can put in there no compensation to be paid. If you don't want to be paid, that's fine. But don't just assume because you're not getting paid that it doesn't matter about the agency relationship. The law states if you're providing professional services, regardless of whether you're getting paid for it or not, you better have a written agency agreement to provide those services. Okay? So a lot of agents have gotten in trouble over that kind of stuff because they're thinking, well, I don't need an agency agreement if I'm not charging for the service, and that is not going to be the case. So just beware of that. Okay.